Solo practitioners are typically out there on their own. They don't have partners, they don't have mentors, they don't have ethics counsel, they don't have general counsel. And a lot of times this isolation creates sort of a vacuum. And mistakes happen. Wills, estates, and trusts, was the number one. The first reason is boomer generation. Just a few strategies that can help you avoid or minimize these mistakes that then lead to the legal malpractice complaints.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now to kick things off, I want to go ahead and introduce our speaker, Tracy L. Kepler. Tracy L. Kepler is the Risk Control Consulting Director for CNA's Lawyers Insurance Program. In this role, she designs and develops content and distribution of risk control initiatives relevant to the practice of law. She collaborates with the underwriting and claims teams to develop and execute strategies for the profitable growth of the program. Tracy lectures frequently at CNA-sponsored events and at state and local bar associations and national seminars hosted by industry-leading organizations. She also writes articles focused on law firm risk control and professional responsibility issues. The webinar that you're about to watch will be approximately 1 hour, and once that is complete, time permitting, Tracy will be taking questions from the audience. If you have any questions that come up, please feel free to submit them at any time by clicking the Q&A button in the control panel at the bottom of your screen, and we'll take a look at those once the presentation is complete. Now, without further ado, here is Tracy to discuss lawyers' liability, the game of risk and reward.
Nina, thanks so much. I really appreciate all of you joining me today. This is a subject matter that is directly related to what I do. And so I hope you enjoy the presentation, that you learn a few things, and we're also going to go through some of the ethics rules that fit into this category so everybody can get their CLE legal ethics credits. As Nina said, I'm actually now the director of risk control for this division. My contact information, my email, cell phone number, direct dial number, please feel free to give me a call, especially if we don't get to questions today. Always happy to hear from listeners. What kind of lawyer would I be if I didn't start a presentation without a disclaimer? I just want to say, basically, this is guidance, right? It shouldn't be considered legal advice. These comments are mine and my own, and they don't reflect CNA or our insureds. And this is really for educational and informational purposes. Where are we headed today? What are we going to do in the next hour? Well, let's see. We're headed down this path. We're going to talk about some of the emerging data and trends in lawyers' professional liability or legal malpractice cases. We're also going to look at some of the relevant model rules of professional conduct where lawyers are tending to make mistakes with these rules that then lead to these malpractice complaints. As I said, some trends, some things that may surprise you, some things that may seem very familiar. And then at the end, I'd like to give you some pointers or some best practice tips to really try and minimize your risk of malpractice complaints. So let's jump right in with some data and trends. I think that's a great place to really set the stage for today's discussion. There are a lot of resources out there, but one of the resources that I always turn to year in and year out is the ABA profile of legal malpractice claims. They do this, the Standing Committee on Lawyers' Professional Liability, every 4 years. And every 4 years, insurers like CNA and others from around the country send the Standing Committee their data on claims. That data is then anonymized and repackaged and repurposed into the reports that you see on the screen in front of you. It's available for purchase on the ABA's website. In addition, they give some ideas about emerging trends. And as I said, you can really do a deep dive into the data. In addition to the ABA profile, there's also the Ames and Goff survey that comes out every year that also talks about trends and data and what we're seeing in the industry. I thought it would be fun to start us off with a little bit of a poll to see what you think. Test your knowledge, see what you feel, what's been happening. And the polling question to start us off is, what area of practice do you think receives the most legal malpractice claims? There's no right or wrong answer. This is just for fun and to see where your thinking is. I've given you 4 of them, right? Family law, wills, estates, and trusts, real estate, or plaintiff's personal injury. And go ahead and answer on the screen, and we'll see what gets the most votes. And I'll tell you where the truth lies, at least for these past 4 years. So go ahead and enter that, and I will give you another second or so to do it, so we can move on and give you the answer. See if you were right. Well, what did you say? Oh, look at that. Well, a lot of you said family law, right? Almost 44% of you. 34% of you said plaintiff's personal injury. And surprise, surprise, real estate, 9%, wills, estates, and trusts, 13%. And it actually is wills, estates, and trusts that has risen to the top of this list in this 4 years. For those of you who said the others, in past years, those have been near the top. Truly, plaintiff's personal injury is always at the top. Why? Because the deadlines are missed. That's one of the easiest things that happens in these types of claims. And later, when we talk more about trends, I'm going to tell you why wills, estates, and trusts has moved to the top. Real estate, plaintiff, family law, a lot of commercial transactions, bankruptcy work is also moving up. Not so much for the number of claims, but certainly for the size. And IP, intellectual property, whether it be patents, trademarks, or copyrights, is climbing up as well. So one more polling question, and then I promise I won't bother you with these for the rest of the program. We'll go through it. Another question for you to see what you think. What do you think, what size of firm has the most claims? Do you think it's the solo practitioner who's out there, a small firm, mid-sized firm, or the large law? Where do you think, from a legal malpractice sense, which one gets the most claims in this list? And I'll give you another minute or I shouldn't say minute, a few seconds to answer. And I will go to give you another second or so. If you said solo practitioner, and most of you did, as I can see the results, you'd be correct. I think that is similar in the disciplinary context. It's similar in the legal malpractice context for the same reason, right? Solo practitioners are typically out there on their own. They don't have partners. They don't have mentors. They don't have ethics counsel. They don't have general counsel. And a lot of times, this isolation creates sort of a vacuum where they don't have anywhere to turn. They don't know where to ask the questions, and mistakes happen. And because they don't have the resources, maybe they can't mitigate, ameliorate, rectify. That's where the largest percentage of claims fall. So a little bit more data before we jump into the trends. When we look at the number of claims by activity, when you look at this, it should make sense, right? More than 50% of the claims fall in 2 areas. And it falls in preparation, filing, transmitting documents, commencement of the action or proceeding. Right? It falls in the missed deadlines. You didn't calendar properly. You missed the date. Or maybe you didn't add that party that needed to be there. As we go on down, we can see the other areas that have a high percentage of claims. You don't know the law, right? You gave incorrect or improper legal advice. And a lot of times things come in the settlement or negotiation, whether it be something in litigation, whether it be before a mitigator or an arbitrator, a mediator. even before it gets to a court setting. Errors, poor communication or lack of communication happens in this area, and it leads to that claim. You can see again the number of claims by error. The greatest percentage is obviously substantive errors, and we'll go through that a little bit more in just a second. But then those administrative errors come in. And we'll talk about what those are, as well as client relations, the communications or clients, let's say, not behaving the way they should. And luckily for us, the intentional wrongs are the lowest number as these claims. So the top 6 substantive errors, according to all of the data that has been accumulated and put together by this ABA report, like I said, you don't know the law. You're a dabbler. You're practicing outside the area that your practice generally practices in. You know, you're doing that favor for Uncle Jed in traffic court or a real estate closing, but that's not where you typically practice. So you don't know what you're doing. You didn't have time to self-study, and you don't properly apply the law. Additionally, there are the drafting errors. Those are the cases that we see, you know, that create a huge amount of claim. There's one, you know, where an S was left off, or it's payor instead of payee, or grantor instead of grantee, or just sloppy pleadings, you know, cutting and pasting. You use boilerplate, but you don't put in the actual factual circumstances of this specific case. COI, conflicts of interest, right? That is always the number one cause of legal malpractice claims. It may not be the number one cause of disciplinary claims, but certainly when we look at legal malpractice, that is up at the top of the list. Whether it results in a disqualification, a disgorgement of fee, you know, you have to withdraw from the representation. It subsequently leads to the malpractice issue. You don't do the discovery. It's inadequate. It's not complete. Planning error, procedure choice, you know, who you add in as plaintiffs, which strategy you decide to go with. And then, as I said, you don't know what the deadline is, so you don't meet it. With regard to the administrative errors, they're very similar. And I have to say, and that's why the picture is here, failure to calendar properly. You missed the date. You didn't know the date. You only use Outlook as your calendaring system. You didn't use a tickler to get you, you know, advance notice of the date, to get you prepared in advance of the date. Sometimes it's your staff, clerical errors, or you saw the date and you've been procrastinating and you waited too long. You didn't react. You didn't file. Not because there was a deadline, you just never filed the documents. This is the tough one, and we'll talk about it when we talk about Rule 1.3, procrastination. You know, who starts what they need to do on the very first day? A lot of us, we've got a lot on our plate. We wait until that last minute, and then sometimes it's too late. Or you don't follow up with the client or with the court or with opposing counsel or a third party. And then, you know, those where you just lost the file. Right? I lost the document. I lost the evidence. Which leads me to the first rule. And here we're looking at the ABA model rules because I know this is a program where you all are all around the country. I always like to say, when I'm talking about the ABA model rules, right? No force and effect. They're just models. Please do look at your state jurisdiction's rules to see if there are changes, if there are differences, and what the rule is in the jurisdictions in which you practice. But the first rule is very basic. I mean, it starts off with, look, a lawyer shall provide competent representation to a client. Not too descriptive. We need a little bit more. So the rule goes on to say what competent representation is. The legal knowledge, skill, thoroughness, and preparation necessary for the representation. Even that, you know, defies a little bit of you know, when you define the term with the term. So we're going to dig a little bit deeper. And I always like to turn to the dictionary, right? Let's start there. What does Merriam-Webster say? Merriam-Webster says competence is having the necessary ability, knowledge, or skill to do something successfully. You're efficient and capable, acceptable and satisfactory, though not outstanding. Now, I'm not sure any of us would want to use that definition, certainly on our websites or with our clients. I mean, we all want to be the A plus, but that's what it says, right? Competent. You got it. You've got the thoroughness and the preparation. You've done your work, right? You inquired. You know how to do the analysis, analysis of the facts, the legal elements of the problems. You know the methods, you know the procedures, you're prepared and you do the preparation, and then you apply that all to the client matters. Certainly this is a case by case basis, and the facts and circumstances of the type of case that you're working on, will determine what's required. Certainly, major litigation, complex transactions, that's going to require a little bit more extensive treatments than, something like a speeding ticket, right? So it really is facts and circumstances based. But I do like to point out some other core competencies. And while they may not be in the rule or the comments to the rule, I think they're equally as important, particularly when we come to legal malpractice situations. It's not just what the rules require, but there are some others. I mean, some of them are innate. Some of them, you develop over time and who you are as a person and your identity, right? Integrity, character, intelligence, all of those kinds of things. Collaboration skills, particularly if you're working with a co-counsel, either inside or outside your firm, especially in this circumstance with legal malpractice, because there's joint liability, joint responsibility for the representation. You have to be able to work well, know what the other person is doing, or at least set limits, boundaries, and expectations, and be able to function in this sort of multi-party work environments in this day and age. In some respects, and we'll talk about this with the communication requirement under 1.4, emotional intelligence, right? We have to be detached emotionally from the client and from the matter, but a long way to establishing that trust, that loyalty, comes with the empathy, the perspective, and the personal connection that you have with your clients. There was an ABA Journal article a few years ago that said, look, the number one thing that clients want is somebody to listen, just to take the time so that person can be heard. Certainly financial literacy, knowing how to run a business, balancing a ledger, if you're, tax principles, statistics, all of those kinds of things figure into this. Comment 8 to the model rule, technological affinity, making sure that you keep abreast of technological changes. This comes into play particularly in AI, and we'll talk about that as a trend a little bit later. Health and well-being, you've got to start with a healthy foundation, right? While not in the model rule, it is in some of the states' rules, but you need to be mindful of your mental, physical, and emotional health, as it may have an impact on your ability to represent clients. Time management, that fits directly into this diligence procrastination issue, where we see missed deadlines, in addition to the delegation of work, which was a perfect segue. Just because you delegate the work to another person on your staff, on your team, doesn't mean that you don't have to be competent, right? It still comes back to you. You still may be the responsible party. And there's a great ABA ethics opinion. It's on the screen, 08451, that pretty much states this fact. You as the attorney you still remain responsible, ultimately responsible, for rendering competent legal services. I'll move on to the diligence aspect of this, because I really do think this fits into those categories of administrative errors that we see really high up on the list for legal malpractice claims. The rule is very simple. And what it says is a lawyer has to act, it's mandatory, it's not permissive. A lawyer shall act with reasonable diligence and promptness in representing a client. Well, what does that mean? Let's dig a little deeper. Diligence. Look, constant effort, always working to accomplish what is undertaken. The attention and care expected and required under the circumstances. Promptness, punctuality, timeliness, not procrastinating. And actually, one of the comments to this rule is a statement that says there's nothing more widely resented, hated, whatever, adjective you want to use than procrastination. Clients don't like it, and it leads them, and sometimes it comes to a lack of candor, a lack of trust in your abilities. How are you going to really comply with this obligation? 3 things. You're going to control your workload, right? You're going to try to, there are times when you have too much on your plate. I totally understand that, and I recognize that. And, you can't get started at all. But to the extent that you can control your workload so that you can handle each matter competently, diligently, you won't want to follow this rule. Limiting. As I said, needless delay causes clients anxiety. It probably causes you anxiety, and it can undermine your client's confidence in you. And if you can't comply with the control and the limit, then the next thing you need to consider is withdrawing, right? If unless the attorney-client relationship has been terminated, you really should continue through to the conclusion of all the matters. And you're going to talk about what the expectations and boundaries are in engagement letters. But to the extent that there's no way that you're going to be able to comply with your obligations, rather than going through and performing, at a half level, making mistakes, running afoul of the rules, getting into disciplinary trouble, and ultimately a legal malpractice problem, get out, right? It may be time to get out. The other thing I always say is a lack of diligence may lead to prejudice, but actual prejudice is not a necessary element of the rule from a disciplinary perspective. Also, when we think about this rule, we think about the breach of the standard of care or the duty of the standard of care, particularly in a malpractice setting. You got to look at it from a more macro perspective. And we look at it in total, right? 1.1 competence, 1.3 diligence, 1.4 communication, all coming into this category of neglect. That is diligence's evil twin, right? You don't follow through, you don't communicate with your clients, all of those kinds of things that we just saw a few slides ago where we lead, or the reasons why we have malpractice complaints. We talked about controlling your workload, controlling it so that you can handle each matter competently. And if necessary, delegating work to others, but still recognizing that you are the one ultimately responsible. In addition, in this ABA survey of claims, we look at some of the reasons for errors in the category of client relations. That's where we see, a client, it's the client's objectives and the means you use to get them there. You don't follow their instructions, or you don't talk to them, right? You don't get their informed consent. You don't have conversations with them, or you do withdraw because you need to, but you don't do it in the proper way. Another rule that relates to this scope of representation or this client interaction is 1.2a. And 1.2a talks about, look, you as the attorney shall mandatory abide by a client's decision concerning the objectives of the representation. It goes on to talk about settlements. It's the client's right to settlement. It goes on to talk about criminal matters. But what we're talking about here is, what does it mean? The client, we talk about objectives and means. The client has the ultimate authority. I like this Nastasiak case because it points something out. It says the master of the action, and the client may press it to the end regardless of the weakness thereof. Well, I don't think that is necessarily true, right? It's not without limits. Certainly, the client can suggest what they're hoping to get out of the matter, and you as the attorney use the means, but there are certain limits, right, imposed by the law, as well as your ethical obligations or your professional obligations under the rule. The comments go on in 1.2 to talk about this division of authority, this objectives and means, as I just talked about. Client says, this is what I'm hoping to get out of it, right? This is how I want it to be resolved versus the means. You have the legal skill, knowledge, thoroughness, and preparation, right? All that we talked about under competence. You are the person they came to get the client there. You're the one who comes up with the strategy. You're the one that comes up with the decision of what we're going to file, how we're going to file, motions, this, that, the other. The decisions that are procedural and tactical, those are within your purview. But what happens when you and the client disagree? Well, hopefully, the client came to you because of your, legal acumen, your skill. And normally they're going to defer to you. You're going to get them there. Sometimes they don't. Sometimes they want to go a different direction. And if you can't agree, what are you going to do? Well, hopefully you could find a resolution. You could talk through it. You might withdraw. The client may fire you. But whatever you do with regard to strategy decisions, especially when the client has decided, thanks so much, lawyer, but I'd like to do something else, document. Write it down, what you suggested and which way we're going. The other thing I like to bring to your attention with regard to 1.2a is this implied authorization. And this comes into settlement negotiations, particularly when we think about the malpractice issues. When we look at comment 3, we look at the rule, talks about implied authorization. And is there an opportunity to talk to the client at the very beginning, get, recommendations, ideas on specific action that you're going to take without having to further talk to the client about those issues, right? Can I rely on those initial conversations that we had about maybe I'm not going to, I'll take $50,000, but no less, those kinds of things. Certainly the client can revoke those initial statements at any time. Certainly you should touch base. It doesn't mean I get to do whatever I want, but there is some certainty or some security, I should say, in this implied authorization and these conversations. Speaking of conversations, the other rule that fits into this category of neglect that we see and the breach of the standard of care that we see in the legal malpractice actions is communication. All of these rules in the communication 1.4 rule talk about talking, right? Or writing letters, however you communicate with your client. And they are all mandatory. They are all shall rules. The first one, talking about timeliness, right? Promptly informing the client of any decision or circumstance where I need their informed consent, right? Having that discussion, reasonably consulting with the client about the means, right? What you do, objectives, means, how you're going to get them there, having a discussion about it, how I'm going to accomplish that client's objectives, keeping them reasonably informed about the matter. And what am I keeping them reasonably informed about? What's happening, right? And sometimes there may be nothing happening, right? But still, it's a great service to say, you know what, we're still waiting on that judge to rule. We're still waiting on that motion. We're still waiting on whatever, just so they know that you're paying attention and that you have a handle on it. Sometimes some things where you have to inform the client, it's an awkward conversation, but you need to do it. Client's case was dismissed. You made a mistake. You don't follow client's instructions, having a discussion. And what I will say here is, we all know the adage, the statement, the cover-up is worse than the crime. That applies here too, not only with disciplinary investigations, but with legal malpractice. Many of you have heard the term fraudulent concealment. It always makes matters worse. If you hide, if you lie, in a disciplinary matter, they're going to add on a charge of fraud, deceit, dishonesty, or misrepresentation, which invariably is going to increase the sanction. And if there's a charge of fraudulent concealment, that may vitiate your coverage under the policy. Honesty is best policy there. The rule goes on to say promptly comply with reasonable requests for information from the client. I think this is probably where most lawyers get into trouble on this promptness or what they need to say. The client doesn't know what's going on. They may call you every day. What is reasonable? How do I respond? Should I be texting them? I really do suggest that these conversations about how you're going to communicate be established at the very beginning. Right when you're establishing that attorney-client relationship, putting something into your engagement letter so that everybody involved is prepared and understands, has expectations, but the other side has some boundaries, particularly on the reasonableness issue. And recognizing, as I said earlier, it's a case-by-case basis, right? You may have a client who is a very sophisticated consumer of legal services who doesn't need the same kind of hand-holding or touch that someone who's never hired an attorney may need. Missing clients, making reasonable efforts, as I said earlier, continuing on, so that their legal rights aren't prejudiced and then withdrawing. And also, we have communication issues when we're communicating through third parties. Again, rule communication goes on to say that you have to consult with the client if the client is expecting some assistance that might fall outside of your professional obligations. And we're going to talk about those assisting client in fraud matters later when we get to trends, because that is a trend that we're seeing more and more frequently. As I said, if the client is expecting help that might be unethical or illegal, that's a conversation you're going to have. Can't do it. And the last one here, explaining a matter to the client to the extent reasonably necessary to allow that client to make the informed decisions about what's going to happen and what you're going to do in the case. What types of things need to be explained? Certainly the legal effect of entering into any transaction or executing a document. Informed consent. What are the risks, benefits, pros, cons, potential adverse consequences of getting involved in this or doing it this way? And what objectives are at risk? If we do this, this might happen. If we do this, what might happen? What are the other options and what are the other alternatives? Luckily for us, when we look back at the LPL data, we are very lucky that intentional wrongs or intentional errors by attorneys are the lowest category, right? This category, fraud, malicious prosecution, libel, violation of civil rights, is really low on the list. It goes down in times when, I should say it the other way. It goes up in times of economic downturn, right? The kinds of things that we're looking at are, Ponzi schemes or fraud. Right now, we are in a period of maybe, well, it depends, I guess, how you look at it, economic upswing, maybe downturn. Maybe we'll see these numbers turn around in the next 4-year survey. But for this 4 years, down. This is not to say that intentional wrongs committed by clients is down. In fact, I think that is up, and we're going to talk about some of that. Look, right now, when we talk about trends in lawyers' professional liability claims. When some of you said wills, estates, and trusts, was the number one, some of you said, here's why, right? The first reason is this enormous amount of wealth that is being transferred right now from the baby boomer generation on down to other people, in the life cycle, right? Huge transfer of wealth, lots and lots of money, leading to lots of money on the hook in the claims when it's done poorly or incorrectly. In addition, sometimes we have clients who come before us who want these services, who may have diminished capacity. They may be in a situation where they are taking direction or are being directed by a relative who doesn't have their best interest at hand. Maybe they are being subjected to some undue influence. And we as the attorneys are not recognizing either the diminished capacity or that somebody else is trying to direct the way we are operating in the legal services that we are providing. A lot of times, it is partly a problem because you did not define who was your client at the very outset, right? This is a engagement letter problem. Beneficiaries come after the fact. They think that they are the client. They want to sue. They want to bring the malpractice matter. They're talking to you as if they're the client. There's a conflict, and there may be errors in the estate documents that were drafted. Certainly, what we're seeing a lot of is attorneys who don't have the legal knowledge, people who are dabbling, people who are creating estate planning documents because Uncle Jed asked them to, right? I am a, environmental lawyer, but how hard could it be to draft a will? I can get the form online. Let's go ahead. And what's ending up happening is that it turns out to be much more complex than they ever thought. They do what they do, not realizing it until their client, is deceased, and then it all falls back. So the placement of assets is incorrect. Deeds are not being transferred properly, or they're not being recorded properly. Tax deadlines for the estate returns are not being done properly, or this was not, it's a scope of representation issue. We thought we were doing it. You weren't doing it. Again, heading back to that engagement letter problem. Again, conflicts of interest. Who is my client? Who am I representing? Being very clear about that at the outset and all through the representation, particularly when you are a person, even if you specialize, I shouldn't say specialize, even if this is your practice area, when you're representing a multi-generational family, making sure that things are clear cut and decided at the very start. The other thing that I will say is in these claims, they are very fact specific, and they are expensive. They are time consuming to figure out. And a lot of times there are multi-million-dollar estates where the damages can be huge. Some other trends that we are seeing, and we talked about this a little bit, an increase in claims in intellectual property. There are several reasons why this is happening. And I think the first one is really increased complexity and the stakes, right? IP law, particularly in the patent area, is becoming increasingly complex. It has all kinds of intricate legal procedures, technical details, and this complexity makes it really easy for mistakes and errors to happen during the prosecution process, during filing, deadlines missed, inadequate claim drafting, failing to protect trade secrets, whatever the case may be, that's what we're seeing. In addition, the dollar amounts, right? There's a high value here. For a lot of companies and clients, IP represents a significant portion of their assets. And protecting these rights is crucial. And when there's a failure or an error or a mistake, it leads to huge financial losses, making attorneys a prime target for malpractice claims in this area. The last thing I will say is, malpractice claims in IP can involve high value transactions, 7 to 8 figure payouts. And another thing that we're seeing are particularly aggressive plaintiff firms, right? Some plaintiff firms are really now employing tactics borrowed from what we see in class action matters, which really increase the scope and the impact of malpractice claims. Another thing that we're seeing is a decrease in criminal claims. Why that's happening, hard to say. Maybe there are less criminal claims less criminal matters actually being prosecuted as we see the rates of crime going down. But what we are seeing on the other side in personal injury is a rise and settle and sue. And for those of you who are unfamiliar with that term, what it means is, a client, you've had communication, right? 1.4, 1.2a, you've had the conversation with your client about settling the case. The client says, yeah, okay, great. I'm all right with that. Let's settle. And then later, the same client has sort of, buyer's remorse and sues the attorney, claiming that the attorney failed to work up the case properly or, didn't communicate properly, and that they felt they were forced to settle for less than the case was worth. We're seeing a lot more of those types of issues. Another thing that we're seeing is one of the trends is in frequency and severity. The number of claims is going down, but the amount is going way up, right? As you can see on the screen, 70% paid claims, you can see the dollar amounts, right? 3 paid more than 100 million, 2 paid more than 300 million. We're not talking about little dollar amounts here. In fact, sometimes we're not even talking about million. In one case that was recent, we're talking about billion. And that was a case where an S was left off. An S. It's happening a lot more in commercial transactions and business transactions. The good news here, and I always like to have some sort of positive, is that insureds are recognizing that there is liability, recognizing when the problem, anticipating potential problems. They are reporting earlier potential claims. Insurers are getting on board earlier so that there can be early intervention to ameliorate or lessen the severity and the dollar amount of these claims. But, here's the latest one that we saw back in 2020. The largest to date was $390 million settlements. And what I have to say here is, and it's something I alluded to earlier, the most common cause of a catastrophic claim is an unworthy client. Somebody that you may or should not have had as a client in the first place. Someone that was asking you to do something that was unethical, was asking you to assist or facilitate in a fraud, or you prepared the documents and then they fraudulently altered them later, leading to this claim. It's client fraud directly, or the lawyers who are aiding and abetting this client fraud. And I'll turn to another ABA model rule of professional conduct here when I look at 1.2D. And this rule speaks directly to the ethical obligations in this instance. It's a scope of representation rule. And what the rule says is a lawyer shall not, mandatory, counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. The rule goes on to say, you don't want to just leave people hanging, right? In these rules, the rule goes on to say, look, you can't engage, you can't assist, but I am allowed to discuss the consequences of any proposed course of action with the client, right? And I can help the clients, I can assist the client to make a good faith effort to determine the validity, scope, meaning, or application of the law. So I can't help them, I can't assist them, but we can figure it out, right? I can tell them the alternatives. That I am allowed to do. If the client uses your advice, in a course, in a proceeding, and then it's criminal or fraudulent, it doesn't necessarily mean that you're a party to the action, but certainly it can get you into disciplinary trouble and into a legal malpractice claim in the end. I always say, the ostrich defense, failure to ask, failure to inquire, putting your head in the sand and pretending it's not happening is not going to protect you either in a disciplinary matter or a legal malpractice matter. Additionally, not last summer, but the summer before, The ABA model rule was changed when we're talking about termination and withdrawal. 1.16a is on the screen in front of you, and this is how it was changed. And it really goes to this knowing your client and the due diligence that is required to make sure that this client isn't acting fraudulently, criminally, all of those kinds of things. And it talks about, look, comment 4 is the operative, really important part here. If the client or the prospective client seeks to use or persists in using your services to commit or further a crime or fraud, despite having that conversation that we just discussed under 1.2d, you got to get out. You got to withdraw. What does it mean for lawyers? This is nothing new. We've always had this obligation to sort of do our due diligence into who our clients are. Right. The duty is not just at the outset when they're coming in as a prospective client and becoming a client and signing that engagement letter. It goes on throughout the course of the representation. If the facts and circumstances change, if a new matter comes in, you've got to inquire. You've got to evaluate. You need to be on board and do this risk-based inquiry all throughout the representation. There's a lot of good guidance in the ABA model rules. You can look to them online. Again, this comes into play a lot of times with money laundering, with trafficking, with terror financing, and recognizing that this assessment, this looking for the red flags, is not a one size fits all. You're not going to do it the same way for every client. It's really going to depend on that client matter and who that client is. And if there is something, what do? You've got to terminate. You've got to withdraw, because otherwise it's going to lead you to being one of these statistics, one of these claims in the malpractice survey that they do every 4 years. Right? As I said, this is nothing new. We have always had this obligation. We have always had to perform some due diligence on our clients. Who we're going to represent, what matters we're going to represent, and some red flags and warning signs that you want to look for with these clients. Poor finances. They don't want to meet with you. They're only sending emails. They have a long history of firing and suing other attorneys. They've come in at the 11th hour asking you to do something, on a very time-sensitive matter. Or how about this one, right? The hairs on the back of my neck are standing up. My spidey sense is being activated. I've just got a bad feeling. Something's not quite right here. Don't forget to listen to that, because if you do, there are huge risks to you when you don't perform your due diligence on these potential clients. Not only is the risk of legal malpractice greater, there's disciplinary action, lost money, disqualification, criminal action. We'll talk about that in a minute. And sort of be immeasurable, in dollar amounts. The reputational damage to your law firm when this becomes the latest and greatest story in Law 360. A few things that you want to consider when you're doing this due diligence, right? Depending on what your practice size is, whether you're a solo, small firm, boutique, large, right? Committee, making checks, researching your clients, going into, taking steps, maybe even having a checklist. Heading back to some other trends, I want to get back to talk about what we're seeing. As I said earlier, incidences arising out of trial, arising out of settlements, all kinds of communication errors, and this one. And I think this is a topic of conversation among many of us. I'm speaking specifically about AI, which I'll get to in a minute. First of all, there are fewer cases proceeding to trial, and these technological advances are causing a real problem, right? Calendaring errors, yes, we've talked about those. They're still on the rise. It's human error. We're not doing it properly. We need to be more circumspect. The AI issue, while I have not seen a legal malpractice claim, I think all of us have seen civil sanctions, civil court cases where this is becoming an issue with the hallucinations. The other issue, filing cases that don't exist, right? We're talking about candor to the tribunal. What we haven't seen quite yet is a violation of the duty of confidentiality if material has been put into AI and has seeped out. Um, you know, that we've seen about the inaccurate, but we have to be very careful here. And that was really interesting to me. Just the other day, I saw a firm in the United Kingdom. It was the first law firm that's providing legal services through artificial intelligence, been allowed, right? Well, I mean, many of us are already using it in the back of the house to do research, not the public facing services. This firm, it's called Garfield Law, is the first purely AI based firm that the SRA has authorized to provide regulated legal services in England and Wales. I say it as an aside because it is happening, right? People are relying on it more and more. Errors are happening. We're seeing it in the courts. I'm wondering how soon it's going to be before we see a legal malpractice case related to it. The other thing, the texting, the Snapchatting, the WhatsApp, the emojis, the way we're talking to our clients, the way we're communicating. Think back to 1.4. What is missed? What does the letter K mean when a client texts you K, or prayer hands, or a thumbs up? Is that consent to a contract? Is that consent to the settlement offer? I don't know. Do you know? In what context are these being used? We have to think about those kinds of things. I've seen a lot of civil cases around the use of emojis. The other thing I say with texting is the danger of a hasty response, right? The immediacy of the text. Clients have become accustomed to quick results. They send a text, they see that you read it, and where's my response? 30 seconds later. I don't know about you, but I would like my lawyer to think about it for a moment. I would like there to be a cognitive pause. I would like some legal analysis, some bespoke legal services coming into the decision, not just off the cuff, off my head. Expecting these outcomes in minutes leads to all kinds of blunders, errors, misdirected messages, mistakes, that embarrassing message that you send, and sometimes improper legal advice that ends up in a legal malpractice case. Cybersecurity. In this day and age, I hate to say that it is impossible to, guard against, that it won't happen. Your best mechanism, as I said, is to guard against, have an incident response plan, because what we are seeing, and lawyers are subject to unprecedented levels of electronic attacks, whether it's spoofed emails, phishing emails, people who are intercepting the transmission, ransomware, the fraudulent or wire transfers. What we're even seeing is deep fakes, where support staff think that they're speaking to someone on Teams who's their supervisor. That's directing them to do something, that they ought not do. We're seeing all kinds of incursions into law firm systems where they're getting sensitive and confidential information. And it's going unnoticed. Law firms have tons of personal identifying information that hackers would love to get a hold of. Oftentimes, it's not discovered. Oftentimes, there is a lack of IT oversight. And so that information goes out, gets out in the dark web. And it is really problematic from a trend claims LPL perspective. It requires increasing levels of vigilance, of diligence, of safekeeping confidential information, client funds, privileged documents, and really increasing the sophistication levels of your information systems. The other thing to think about, when you talk about electronic discovery and the volume of material that is being sent or distributed in electronic discovery, and what you have to sort through, not only is this complicating matters, it's certainly making the cost attorney's fees, all of those kinds of things, when you talk about the legal malpractice claim, rise exponentially. In right now, a lot of people, there's less hesitation to sue. Although in some respects, what I will say is, these long-standing relationships that clients used to have with their lawyers, in this day and age are really a thing of the past. I think the process has become more transactional. There's less loyalty. They may not have thought about the process as much as they would have in the past. And the other thing that we consistently see and that is not recognized and really goes back as I talk about engagement letters, we talk about the billing, right? If you don't have good billing etiquette in place in your practice, you're not handling it all throughout the representation, the client is slow to pay or the client doesn't pay, you sue them for the fees. And guess what? Nearly 50% of the time, nearly one half of the time, what's going to happen? A counterclaim for malpractice, right? That's why billing and sorting that out from the beginning and all through the representation is key. So going back to this client fraud, and I'm going to end up my discussion with these kinds of cases, the high risk litigation and client behavior. I talked about the fee disputes, 50% of the time turning into legal malpractice counterclaims. There's also the issue of litigation funding and the conflicts of interest that can potentially arise when there's a litigation funder involved, when the client is worried about not getting their money back out, when there's been a settlement offer, how it's going to proceed. Is the communication there? Has everything been discussed above board, informed consent, so that there's not this sticker shock at the end and we go back to the settle and sue issue, in addition with the excess verdicts. Aiding and abetting business misconduct is one of the trends that we're seeing more and more. As I said, this happens in the commercial transactions area when you are also with the incorporation, right? You are representing a business from, soup to nuts, from the beginning of the incorporation, who are the parties, who are the subsidiary, all of that, all the way through, 1.13, organization as client, who can I be directed by, who's doing what, and the increased vigilance and diligence that is required in looking into who is my client. I mean, if you're thinking about representing the organization, you are representing the thing and you are doing what's in the thing's best interest. Oftentimes, the players, the other people involved in the corporation, are not acting that way, or they may be involved in criminal or fraudulent transactions that you are aware of, you're not aware of, you need to be aware of, right? Unworthy client claims also arise out of litigation practices. We saw recently a $42.6 million settlement by a New York firm whose client actually falsified the evidence that was submitted. As I said earlier, IP litigation is fertile ground for unworthy client claims. And you can see some of the other dollar amounts that are involved when you take on this risky client or this client who may not be above board. The other thing to consider, right? Criminal liability. Your client commits this fraud. Either you are a participant to it, you are actively involved in it, or they are doing it, taking what you have created and then doing it on their own. Orange jumpsuits are not flattering. You have to remember that in addition to your disciplinary liability, your professional liability, the legal malpractice, there may also be criminal liability that happens here as a result of engaging in these, engaging with these nefarious clients. We've got a few cases up here, the Even Griebel case, Joe Collins, the Rimberg case back in 2020. And I like this, describing a lawyer's role in a money laundering scheme. Guess what? That he didn't feel good about when first approached, but naively participated given his misgivings. This is the spidey sense I was talking about, right? I don't think this is quite right, but I'm going to do it anyway. And then the consequences. As I said, with corporations, closely held entities, private entities, partnerships, and foreign companies, these come into play. There can be problems there. You have to be extra vigilant. I talked about the clients who don't pay your fees or who are engaged in slow pay. Competence clients who are just a hot mess. Incompetent clients, the ones who come to you who are completely disorganized. They don't have a budget. They don't have a business plan. They can be just as unworthy from a legal malpractice perspective as those who manage everything appropriately, but are ne'er-do-wells, if you will. The other thing I say is, being a firm with an excellent reputation really is no insulation, because dishonest clients are going to seek you out. They seek out the good firms because they see that reputational transfer, right? It sort of makes them okay. It makes what they're doing okay. It will look good for them. And then always, when we talk about unworthy clients, we also have to talk about non-clients, because this gets lawyers into legal malpractice problems as well, and is always a consistent trend. When we talk about, the accidental client, or the, client you didn't expect, whether it's because you were providing legal advice on your website, to a question that came in from a contact us, where you didn't sign an attorney agreement, and you didn't send a declination letter, whatever the case, being very circumspect of those accidental clients, because they can get you into trouble. Last couple of points. We talked a little bit about this when we talked about competence. I say attorney well-being, or oxymoron. So many cases. In fact, there are studies that show 60% of all disciplinary and legal malpractice cases have at their core some mental health issues or substance use disorders or cognitive impairments on the part of the lawyer that the lawyer didn't realize, that was impairing the lawyer's ability to represent clients adequately, competently, diligently, zealously, whatever word you would like to use, not recognizing that they need to withdraw and they have an obligation to withdraw under 1.16. Another area that we see where trends are rising in malpractice claims as the basis or one of the factors for the breach of the duty of care. The other thing is, look, mistakes are everybody's problem. It's not just the one person. Especially, you have to look at everybody who's involved. Even if you're in a solo practitioner, the people you partner with, your IT professionals, the outsourcing, and being very mindful of that. And as we finish, just a few strategies that can help you avoid or minimize these mistakes that then lead to the legal malpractice complaints. I talked about this one earlier. That was my Uncle Jed, who was doing my wills, estates, and trusts, right? Discouraging dabbling. When you focus your practice in one or two areas, claims rates go down. There's data to support this, not only from where I work, but from other firms as well. When you practice in 6 or more practice areas, malpractice claims go up because you don't have the competence. You don't know what you're doing for all those reasons that we earlier discussed. Using caution when you're, using documents from prior matters, that cut and paste, that boilerplate. We're in such a hurry. We were procrastinated. We just, look for something on our computer. We put it in, but it bears no relation to the case at hand. Printing copies, right? Rather than reviewing on screen. How many times have you looked at things and you're like, oh, my eyes are tired, I can't look, and then you miss it? that one missing S problem, as I discussed earlier. Certainly, having docketing and calendaring systems in place, something that you can double check. I mean, if you want to use Outlook, great, but have something else. Have, a double check, a triple check even. Use ticklers. Use, this is coming, making sure that you've got everything and that you actually know what the deadline is. Checklists are very helpful. Being able to cross things off or check that it's done as you're going through the process. Having clear scope of engagement or representation letters in your representation statements in your letters. This is what I'm going to do. This is what I'm not going to do. So you don't have the matter creep and the blur that leads to confusion. The client thought you were going to do this. I never thought I was going to do that, leading to a malpractice case. We talked about the objectives and the means. We talked about when the client says, yeah, I like that, but I don't want to do it. Okay. Client does not adhere to your strategy advice, wants to go in a different direction. Write it down. Document it in your file. Maybe even send a confirmatory letter saying this is what we discussed. This is what you decided. This is how we're going to proceed. It's a great CYA. Certainly, having conflict checking systems and making sure that you're doing those conflicts from the beginning and all throughout the representation, particularly if a new matter or a new person is added to that matter, including the affiliates of prospective corporate clients and adversaries in your searches. If you are in a bigger firm, circulating these matters to everyone so all personnel, all staff can be aware and raise their hand if they see something that's not quite right. As I said, these conflicts of interest are not static. They are fluid. They change when the matters change, when you bring in additional parties, and you have to do it at times all throughout the representation. Identifying prior work conflicts, and then certainly the informed consent, most of the times in writing, and it can be countersigned by the client, all the better. With that, I think I have gone over my time, Nina. I'm sorry. I will zip my lip and let you speak.
No problem, Tracy. Thank you so much for all of that wonderful information. We really appreciate it. We want to thank you all so much for being here for another Justia webinar. Before you go, don't forget that Justia Connect Pro gives you access to CLE credit opportunities for live and on-demand webinars just like this one, so you can stay informed and meet your requirements. Plus, Pro members also enjoy an enhanced profile, the AI-powered Justia chat to get you more leads on your Justia lawyer directory, and exclusive discounts on Justia marketing solutions. To learn more, you can go to pro.justia.com. Thank you so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.